Now, let's get into this. A black man was sentenced to death for an interracial marriage, but the Supreme Court, they have declined to hear the appeal to overturn the death sentence for this black man, whose jury included three white people who explicitly said they opposed interracial marriage. Now, let's get into the actual story because Andre Thomas, who is black, he murdered his white wife and two children while in a psychotic state and was sentenced to death by an all-white jury, including three members who had said they opposed interracial relationships. So were they biased? Now, the conservative majority court's decision not to hear the case over the dissent of the court's three liberal justices leaves in place Andre Thomas' conviction and death sentence. No jury deciding whether to recommend a death sentence should be tainted by potential racial bias that could infect its deliberation or decision, particularly where the case involved an interracial crime, wrote liberal Justice Sonia Sotomayor. She was joined by fellow liberals Elena Kagan and Ketanji Brown Jackson. The court has a 6-3 conservative majority. So in 2004, Thomas murdered his estranged wife, Laura Bourne, who was white, their 4-year-old son, Andre Bourne, and his 13-month-old stepdaughter, Leah Hughes, in Sherman, Texas. He stabbed all three to death and attempted to remove their hearts, saying later he hoped to set them free from evil. According to court filings, he also attempted suicide. Now Thomas, now 39, later turned himself in and confessed at that time while awaiting trial for the murder of Leah Hughes, in which he claimed he was not guilty by reason of insanity. Thomas gouged out one of his eyeballs after reading a passage in the Bible. And you know, if one of your eyes sin, pluck it out. So after reading one of the passages in the Bible, he gouged out his eyeball. And then later, years later, he removed his other eye and ate it. Now, prosecutors agreed that Thomas was in a psychotic state when he committed the murders, but countered that it was caused by Thomas' actions in ingesting a cough medicine that caused irrational behavior. At the 2005 trial for the murder of Leah Hughes, the all-white jury found that Thomas was guilty and sentenced him to death. In contesting his conviction, Thomas' lawyers argued that the jury was tainted because three members during the selection process had expressed opposition to people of different races marrying or having children, which was pertinent to the facts of the case because of Thomas' marriage to Boren. One juror said he opposed interracial relationships because it was against God's will, according to court filings. Another said we should stay within our bloodline when asked the question. The third juror said interracial relationships are harmful to children because they do not have a specific race to belong to. Now, at the trial, the prosecutor also asked the jury, are you going to take the risk about him asking your daughter out of your granddaughter, or are you going to take the risk about him asking your daughter out or your granddaughter out? Thomas' lawyer said the statement appealed to the jury's biases. Thomas says his right to a fair trial under the Constitution's Sixth Amendment was violated on two counts: that he was not tried by an impartial jury, and that his lawyer was ineffective for failing to object to the jurors being selected. The state's lawyer argued in part that all three jurors said they would follow the law as instructed and could deliver an impartial verdict. Now, if you believe in something, right, like these three jurors, they believed that interracial marriages, they believed that interracial marriages should not happen, should not occur. And they gave specific reasons why. Against God's will, children don't have a place to belong. And let me see what the other reason going back was. Let's see. Let me find that. What was the other reason? And that We should stay within our bloodline. So if they believe those things and they don't believe in interracial marriage, then I would say that they would be biased and there would not be a panel of impartial jurors when you have three that believe a certain way. And there is nothing with what you want to believe. You have that right to freedom of expression, to believe what you want to believe. And so I think that Mr. Thomas made some good points as far as, not having an impartial jury. But did they prove that he murdered his wife and his children? There's always loopholes in a lot of cases that prosecutors will use. But it's not really, I guess, about that part of it. It's about him saying that he didn't get a fair trial, and the Supreme Court decided to not hear the case. They actually declined it. They didn't want to hear it. They said, we don't want to hear that, and so we are going to decline listening to that or taking on that case. And so they chose not to take on the case. And this is what they said. Though the 6th conservative Supreme Court justice did not provide a justification for their decision, liberal Supreme Court Justice Sonia Sotomayor wrote a dissent saying that Andre Thomas' 2004 conviction and death sentence clearly violate the constitutional right to the effective assistance of counsel. Because that was one of the things too, obviously, was, that was one of them, was about the impartial jury, but he didn't have he said his attorney didn't argue a specific point. And so, which you do have a right to effective counsel. And she's saying he didn't. And she was joined by Justice Ketanji Brown Jackson and Elena Kagan. But however, they did not, turn it. They didn't take it. They declined it. Thomas' appellate attorneys had argued that he had received ineffective counsel from his lawyer who failed to object to the jurors, and that he had not received a fair trial from an impartial jury. The notorious conservative Fifth Circuit upheld Thomas's conviction, a ruling Sotomayor said she would have vacated. Now, it is ultimately the duty of the courts to confront racial animus in the justice system, Sotomayor wrote, quoting retired Justice Anthony Kennedy's opinion in a similar 2017 case. That responsibility requires courts, including this one, diligently to safeguard the fairness of criminal trials by ensuring that jurors do not harbor or at the very least could put aside racially biased sentiments. And that's what I said. That's bias. Is that bias? It is bias. So the errors in this case render Thomas' death sentence not only unreliable but unconstitutional. Sotomayor wrote in her 15-page dissent, I would not permit the state to execute Andre Thomas in light of the ineffective assistance that he received. Though the Supreme Court's 6 conservatives offered no defense of their decision not to hear the appeal, the move mirrors positions they took during the last highly controversial term. Now, in May, the Supreme Court ruled in Sheehan versus Martinez-Ramirez that the federal courts were unable to open evidentiary hearings on claims of ineffective counsel if those claims weren't first raised during state criminal proceedings, a decision Sotomayor also dissented from and called perverse and illogical. And then they give another case during the last term, Vega versus Tico. The court ruled that defendants who've been deprived of their Miranda rights cannot sue the police officers who deprived them of those rights. In her dissent, Kagan wrote that the Supreme Court injures the right by denying the remedy. And then sometimes as a result, a defendant will be wrongly convicted and spend years in prison, Kagan wrote. He may succeed on appeal or in habeas in getting the conviction reversed, but then what remedy does he have for all the harm he has suffered? So here we are, you all. There's a lot of cases going on now that are becoming very public, where we can kind of learn some things and broaden our horizon, right? in these cases. And so leave your comments below. I wonder, you know, because of an impartial jury, because of ineffective counsel, if those are your amendment rights, why is it that those rights are being overlooked? That's my question. Why are the rights being overlooked, the amendment rights under the Constitution being overlooked, if those are our rights when it comes to juries, when it comes to trials like the impartial jury? Can they be impartial? Which they weren't. They were biased. We know they were racial biased. 3 of them didn't believe in it. Effective counsel. When you have ineffective counsel, you have a right to effective counsel, but ineffective counsel, when those things come up, why aren't they addressed to where convictions can be overturned or sentences can be reduced? Why is that? Why is that? So give me your give me your opinion on that. Give me what you think, or if you know the law, or you have, because everyone has some type of useful input. So give me your respectful, useful input on what you think about this. Thank you all.